This film is a project of the Leonore Annenberg Institute for Civics of the Annenberg Public Policy Center of the University of Pennsylvania, in partnership with the Annenberg Foundation Trust at Sunnylands. Citizenship is every person's highest calling. Back in medieval Europe, punishment could look something like this. But this doesn't happen in America because the Constitution won't let it. The Eighth Amendment says excessive bail shall not be required, no excessive fines imposed, nor cruel and unusual punishments inflicted. Now, we've all heard the phrase cruel and unusual punishment, but what does that mean?
When the founders utilized the terms cruel and unusual, they were looking at two different concepts.
Cruel can mean physical harm or pain like torture. It can also mean a sentence that's not proportional. It doesn't fit the crime.
You wouldn't want to see somebody go to prison for life for stealing a penny.
Okay, that's pretty clear, but unusual, that's a little tougher.
Sentences that have simply become so rare and so uncommon that we no longer see this as an appropriate sentence.
To understand what's unusual, you have to be clear about, well, what's usual? Here, try this. In 1804, the sitting vice president at the time, Aaron Burr, shot and killed Alexander Hamilton, one of the most significant framers and, more recently, the star of his own musical. It was a duel, and dueling up until that day was a pretty common way for men of that period to resolve disputes. To them, it was usual. To us today, dueling is about as acceptable as...
The significance of the Eighth Amendment is that it imposes limits on the kinds of punishments that the federal government can impose on the citizens.
So the framers wrote cruel and unusual to be defined by what's normal or acceptable to each generation.
That's a clause that in our history has played a very important role in seeing that punishments that might have been lawful back in the 1600s are no longer lawful.
Things like prisoners being tortured on the rack, quartered, burned alive.
And how much it can change is up to the courts and the people to decide.
It forces a qualitative judgment on the part of future decision makers to decide for themselves what counts in their own time as cruel and unusual punishment.
It's really a continuous commitment by the courts and the Constitution to make sure that when we punish someone, it is consistent with the beliefs of the country.
And you can see how those beliefs change when it comes to juveniles and the death penalty. Christopher Simmons was only 17 when he committed a terrible, brutal crime.
Christopher Simmons' crime was a particularly heinous murder.
On September 9th, 1993, Simmons and another teenager broke into a home in Fenton, Missouri. When the owner of the home, Shirley Crook, woke up, Simmons tied her up, drove her to a nearby bridge, and threw her into the river. Shirley Crook drowned.
It's hard to imagine something more horrific, something more terrifying or horrifying.
Simmons was arrested the next day.
He confessed to the crime, and he also engaged in a reenactment of the crime for the police, and both the confession and that reenactment were introduced into evidence at his trial.
Simmons was convicted and sentenced to death. But what happened next redefined how we treat juveniles in our criminal justice system. It also redefined what we as a nation consider cruel and unusual punishment. Okay, we'll come back to the Simmons case, but a few things first. Even when only applied to adults, the death penalty has been controversial for a very long time. There was actually a 4-year period in America when the death penalty was unconstitutional. So many states imposed it in so many different ways, being sentenced to death came down to race and where the crime was committed. So in 1972, the Supreme Court said the death penalty was discriminatory and arbitrary and struck it down in a case called Furman versus Georgia.
The Supreme Court of the United States struck down the death penalty, but they said they didn't find it unconstitutional forever.
The Supreme Court said the death penalty, as it was then practiced, was unconstitutional.
But there was enough support for the death penalty that state legislatures across the country rewrote their statutes to comply with the court's ruling. And 4 years later, the death penalty was reinstated nationwide.
States made some changes. We could debate whether those changes made the death penalty system better or worse. 1976, the Supreme Court says in Gregg versus Georgia, those changes were enough.
When it comes to punishment, children and adults are not treated the same. We have an adult system, and for over a century, we've had a separate system for punishing children under 18 or juveniles.
The first juvenile court was created in 1899 in Cook County, Illinois, and it was created out of a sense that we weren't getting it right with respect to children.
The goal of the juvenile justice system was to determine what was in the best interests of the juvenile offender and essentially provide necessary services and rehabilitation.
In most states, if you're charged with a crime below the age of 18, your case will go before a juvenile court. Compared with the adult criminal courts, the juvenile system is generally more forgiving.
Juvenile records are sealed, there are a lot of services provided, and the goal is rehabilitation. They want to rehabilitate the children and get them to a place where they are being productive members of society.
Even after the death penalty was reinstated, juveniles were rarely sent to death row. But in the 1980s and 90s, that changed.
The crime rate increased dramatically during the 1980s. It increased for adults and it increased for juveniles. The crime rate peaked in around 1993. But during this time, when crime was escalating, you have a lot of politicians saying, this has really gotten out of control.
Got about 6 years to turn this juvenile crime thing around, or our country is going to be living with chaos.
Particularly in the late 1980s and early 1990s, state legislatures felt compelled to make it easier to try children in the adult criminal justice system.
You couldn't run for dog catcher in many parts of the country if you didn't support the death penalty.
So as crime increased and more children were sent to adult courts, pressure mounted on juvenile courts to hand down harsher penalties.
And critics of the juvenile court said, we've got to do something about this. And they said the reason that juveniles are committing so many crimes is that we're too easy on them in the juvenile court.
This harsher treatment of juveniles didn't go unchallenged. In 1989, the Supreme Court took up the issue of whether executing a juvenile violated the Eighth Amendment. In a case called Stanford versus Kentucky, the court looked at whether a death sentence given to a 17-year-old constituted cruel and unusual punishment under the Eighth Amendment because juveniles tried in adult court receive harsher penalties than those tried in the juvenile system. And the court said no.
The court ruled that it did not violate the cruel and unusual punishment clause of the Eighth Amendment to execute those who were juveniles at the time of their offense.
Writing for the majority in a 5-4 decision, Justice Antonin Scalia argued that executing a juvenile did not violate the cruel and unusual punishment clause because too many states permitted it, so it couldn't be unusual.
The court, citing evolving standards of decency, looked around the country to see what the states were doing and found that there was not a national consensus against executing those who were juveniles at the time of their offense.
Remember that phrase, evolving standards of decency.
Evolving standards of decency comes from an early 20th century case called Trop v. Dulles, which really had nothing to do with the death penalty.
But it has everything to do with the Eighth Amendment. Chief Justice Earl Warren was the first to use it. Earl Warren was appointed by President Dwight Eisenhower in 1954. As Chief Justice, he oversaw what legal historians call the due process revolution, cases that guaranteed a right to an attorney, a right to be read your rights, and a right to demand that police obtain a warrant to search your home. About the Eighth Amendment, Warren wrote that it must draw its meaning from the evolving standards of decency that mark the progress of a maturing society.
Chief Justice Warren utilized the phrase evolving standards of decency to help the court give definition to how it would assess punishments under the Cruel and Unusual Punishments Clause.
It means that the Founding Fathers understood that society changes and society's views on what is appropriate punishment changes. And so the Founding Fathers built into the Constitution this requirement that while a sentence might have been lawful and used often in 1790, society might come to reject it by 1890.
Evolving standards of decency has become a test that courts apply in Eighth Amendment cases to see if the nation has changed its mind about what is cruel and unusual. And in the 1989 Stanford decision, the court ruled that the juvenile death penalty wasn't unusual because so many states still allowed it. But over the next decade, an important shift occurred in our understanding of juveniles, and that shift was based on science.
The scientific community had done a lot of research on the human brain and the juvenile brain and showed that they're not like adults.
All right, so let's just get our terms straight before we get to the science. Juvenile is a legal term for people under 18. Psychologists sort juveniles into separate groups. Children are the youngest, and adolescents are making the transition into adults.
Adolescents are different from children, but yet they're not quite adults. They're clearly more mature and more capable than children, but they still don't have the full capabilities of adults.
Take a look at this. This is an image of an adolescent brain. In the 1990s, scientists undertook a long-term study on adolescents, scanning the brains of over 100 people between the ages of 12 and 25. And what they found is that not only do teenagers act differently, their brains work differently.
When we now know that the brain undergoes a dramatic series of changes during the adolescent years and into the early 20s, there are three main sets of changes that neuroscientists think are important.
The first set takes place in the prefrontal cortex, right here.
We think of it as the CEO of the brain. It's the brain's chief executive officer. It's the part of the brain that's responsible for all of our advanced thinking abilities, like planning ahead or thinking about the future or logical reasoning.
As the prefrontal cortex develops during adolescence and into adulthood, we get better at things like self-control, thinking ahead, and weighing risk.
A second change in the brain that takes place during adolescence involves a part of the brain called the limbic system. It's a part of the brain that's very important for our experience of emotion.
And during adolescence, our limbic regions go into overdrive.
So when we look at young people's emotions, we see that they have higher highs and lower lows. And then the third major development in the brain during adolescence has to do with connections between different parts of the brain. So the brain becomes much more interconnected.
As our brains develop, the logical calculating prefrontal cortex learns to interact better with the emotional limbic system. We learn to control our emotions better. But all these developments don't happen at the same time. Some parts develop faster than others, and this can lead teenagers to make some bad, often risky decisions.
Josh, do it now! David, try to...
They're impetuous. They're frankly not thinking.
The reason that kids take more risks than adults, we think, has to do with this mismatch between this easily aroused emotional system and the more rational self-control system. Kids may be more likely to overlook the downside of a risky decision.
And what this medical science was showing increasingly is that the key portions of the brain which control impulses, which allow somebody to look at the consequences of their actions, in 16, 17, 18-year-olds are not developed yet. That evidence, that science really caused people to reflect, as I think the genius of the Eighth Amendment requires prosecutors and judges to do.
In other words, as we learned more about the brain, about what's normal in a brain that hasn't fully developed, the courts adjusted. Our standards of decency evolved when it came to the Eighth Amendment.
The court over time has said that a number of things are prohibited by the Eighth Amendment as it relates to the death penalty.
For the first time, the Supreme Court identified a class of offenders who it ruled could no longer be subjected to the death penalty.
But it wasn't a juvenile offender. In 2002, the court took up the case of Atkins versus Virginia.
The Atkins case required the United States Supreme Court to consider whether or not, under the Eighth Amendment, we could constitutionally execute individuals who were intellectually challenged.
In 1996, Darrell Atkins was convicted of murder and sentenced to death, but he only had an IQ of 59.
Everyone's taken an IQ test. The average score is 100.
His lawyers took the case all the way to the United States Supreme Court, arguing that he could not be held as responsible as others convicted of murder because he lacked the capacity to fully understand the consequences of his crime.
The person has to understand what their likelihood of being apprehended is, what the magnitude of the punishment that they're being threatened with is. So it's hard to imagine somebody with a certain IQ actually demonstrating that kind of sophistication.
The American Psychological Association and American Psychiatric Association wrote briefs opposing the death penalty for the intellectually disabled based on developments in the science of juvenile brains.
The American Psychological Association and other sort of experts in the field weighed in as amicus curiae, as friends of the court, and provided the Supreme Court with real expertise about the current standard of science and the understanding of human brain development.
Writing for a 6-3 majority, Justice John Paul Stevens applied the evolving standards test. He said in language that seemed appropriate in its day, "We can't impose the death penalty on a defendant who essentially didn't understand what they were doing. Construing and applying the Eighth Amendment in the light of our evolving standards of decency, we conclude that such punishment is excessive and that the Constitution places a substantive restriction on the state's power to take the life of a mentally retarded offender." And unlike in the Furman case that stopped the death penalty back in 1972, the court ruled this time that most states had clear standards when it came to the death penalty. They refused to sentence intellectually disabled people to death.
It was clear that there was a consensus in the country that people with intellectual disabilities are not sufficiently blameworthy to be subjected to the death penalty.
About 30 states had outlawed the practice of executing the intellectually disabled, and the court said at that point there was a national consensus.
And that consensus set a new standard. The science around the development of the brain had changed minds, and when most of the states refused to execute the intellectually disabled, the court ruled in Atkins that our standards of decency had evolved. If you were intellectually disabled, you couldn't be executed just because you happened to live in one of the few states that were outside of the consensus.
Atkins, in many respects, really provided the blueprint for the next challenge to the death penalty, which was a challenge to the death penalty for 16 and 17-year-olds.
And that takes us back to Christopher Simmons.
He was sitting on death row in Missouri at the time that the Atkins decision came down. And he had a public defender at the time who read the Atkins decision and thought, this sounds a lot like the kinds of impairments and incapacities that children have as defendants, and thought that it was an appropriate time to, in a sense, resurrect a challenge to the death penalty for someone who was 17 years old.
The Atkins decision was based on the idea that 30 states had outlawed the execution of the intellectually disabled, and we now had 30 states that outlawed the execution of juvenile offenders.
On March 1st, 2005, the Supreme Court ruled in a 5-4 decision that executing juveniles violated the cruel and unusual punishment clause of the Eighth Amendment. The court reduced Simmons' sentence to life in prison, ruling that the death penalty is not a proportional punishment for juveniles, that adolescents are not as responsible as adults, so the penalty should not be the same, even if the crime is. Applying the evolving standards of decency test used in Atkins, the court ruled that the national opinion on the juvenile death penalty had changed. A new national standard had evolved.
The court looked around the country again, and what it saw was a shift in what the states were doing, and a shift that was all in one direction, a shift away from executing those who were younger than 18 when they committed their crimes.
Writing the majority's decision, Justice Anthony Kennedy ruled that the change in national opinion provides sufficient evidence that today, Our society views juveniles, in the words Atkins used respecting the mentally retarded, as categorically less culpable than the average criminal.
Justice Kennedy essentially wrote that children have an immaturity of judgment, they're impulsive, they're impetuous when they make decisions.
Justice Kennedy cited the recent scientific data on adolescent development, writing, "As any parent knows, and as the scientific and sociological studies confirm, a lack of maturity and an underdeveloped sense of responsibility are found in youth, more often than in adults."
He said that children had a particular susceptibility to peer pressure. He also recognized that children had a unique capacity for rehabilitation and to change.
The decision in Roper versus Simmons banned the execution of people under the age of 18 across the country. And in the years following Roper, the court has continued to recognize that children and adolescents have a capacity to change. It ruled that the Eighth Amendment prohibits sentences of life without parole for juveniles for non-homicide crimes. It prohibits mandatory life without parole sentences for all juveniles, regardless of the crime. And the court has even overturned the sentences of mandatory life without parole of thousands of older prisoners who were sentenced when they were juveniles, some going back decades. The juvenile justice system has begun to move back towards the rehabilitative model it began with over a century ago.
In 1899, it was really intuition that said, we know kids are different. Today, we have a scientific vocabulary that allows us, through the use of psychological research as well as neuroscience, to put words and names on those conditions and attributes of adolescence that justify creating a more benevolent and a more rehabilitative system.
It's not just anecdotal. It's what we know from scientific studies done by developmental psychologists, done by developmental neuroscientists, that say, not only do we think kids are different, we can prove that they're different.
Today, Christopher Simmons is serving a life sentence for murdering Shirley Crook. The Supreme Court didn't rule that juveniles are blameless for their crimes, but it did say that juveniles, even the most violent ones, are different. And the Eighth Amendment requires us to take that difference into account when they enter a courtroom.
Very often the cases that test the principles reflected in the Constitution involve individuals who are not the most likable people, but the law protects those people as well. And those are precisely the cases that really push us to uphold our principles.
And the very language of the Eighth Amendment means that a fundamental principle is that standards can change. It demands that we pay attention so that our judicial system upholds the standards of our times.
Societies are better off if each generation has to rethink what do we need, at least with regard to criminal law, to make sure our communities are safe and that we treat people who violate the law with dignity. That's our obligation. My generation to do so, yours will, and the next generation coming up, they will as well.